and others.
Mr. Sefton.
My lords, we were looking at some property ownership documents. We'd looked at Birmingham. The other two Mr. Holland referred to are Blackburn and Leicester. But Blackburn is in volume 3, tab 147, page 578. And you'll see it's a transfer from Blackburn Council to 3 individuals who were trustees of the Dewsbury Trust. And it refers to them as the trustees of the Anjuman Islahul Muslimin brackets Maki Masjid. And Mr. Holland said to you, well, that's the description of the Dewsbury Trust. My lords, it's not. If you just keep that volume open, and open briefly volume 1, and go to tab 25, page 248. This is the registration document of the Dewsbury Trust to the Charity Commission, and you'll see it's given the name the Anjuman Islahul Muslimin brackets Madrasa Talim ul Islam. As you recall, that's the name of the property in Dewsbury. This point I was making about trusts being associated with properties. If you close up volume 1 and take up the core bundle, I'll go to tab 21. This is the joint statement in relation to matters to do with the Tablighi Jamaat movement. And if you go to page 304 in that document, you'll see a table. It's a table setting out the post-schism position in relation to where communities congregate within the movement. And if you look to Blackburn, you'll see the first of the 2 post-schism centres is the Maki Masjid, Balaclava Street, Blackburn. Close up the core bundle now. You go back to the transfer, you'll see that the purchasers are described as the trustees of the Anjuman Islahul Muslimin Maki Masjid. But that is a reference to the Blackburn Mosque. And we say that indicates that this was not a transfer to the Dewsbury Trust, but a transfer to those individuals as trustees of a local trust. And that, of course, is consistent with the Dewsbury.
Can you remind me, did the judge make any finding on this?
His finding was expressed quite generally. It's paragraph 66 of his judgment. So, core bundle, tab 10. And what he said, it's about 6 or 7 lines, about 10 lines in. He says, apart from Abbey Mills and the property at Christian Street, the evidence before me does not support the proposition that the Dewsbury Trust owns any properties save in Dewsbury. The accounts don't suggest it. There's evidence tending to show that it does not, etc. It refers to the Zacaroli Trust.
Right, so there's a general finding, but nothing specific about Blackburn.
No specific about Blackburn.
Yeah. Thank you.
So that's Blackburn, my lords. Leicester, this is where the defendants had very much the strongest case, because I accept that the transfer, which is in volume 3 at tab 150, we don't need to take it up, I accept the transfer describes the purchasers as the trustees of the Dewsbury Trust. However, what you also had in relation to Leicester was some evidence which unfortunately is not in the supplemental bundle, but was a witness statement from a man called Ahmed Issat, who was a trustee of the Leicester, it's called the Leicester Marquez Trust. And his evidence was that they had put the names of the Dewsbury trustees on the register out of respect for them because they were their elders. And that was consistent with the fact that, one, the Leicester property never appeared in the Dewsbury Trust's accounts, but two, it did appear on the balance sheet of the accounts for a Leicester Trust. We have an example of the Leicester Trust's accounts in volume 3. It's tab 153, page 609.
Sorry, volume 3.
Volume 3.
156.
153, page 609. The Leicester Trust is a trust that was registered with the Charity Commission. And it was registered pre-schism. And on page 611, you see under the heading Fixed Assets, the charity owns 2 freehold premises, one situated at 162 Needham Street, Leicester, which is functional. That is the mosque property. So, Lords, where we get to is we simply say, well, the judge was entitled to make the finding he did, paragraph 66, on the evidence that he had. And Lords, that takes us up to paragraph 70 and 71 of the judgment. We did look at them yesterday, so I won't take you back to them unless you wanted to go back. But I say they are extremely important, pivotal paragraphs in the judgment. Because what he says there, paragraph 71, is that based on everything he's considered up to this point, he considers that if funds were raised from a local community to buy a market, then unless the contrary had been spelt out, the expectation on the part of the fundraisers and the donors would be for the property to be held on terms that it would be used for and controlled by the local community. And that sets out a baseline against which all of the subsequent evidence has to be assessed. Because this is a finding that doesn't relate to Abbey Mills. This is before he starts to look at the fundraising for Abbey Mills. This is just a generalised finding as to what the expectation is likely to have been. And the reason we say this is so pivotal is because the appellant's case was, we're the Dewsbury Trust, we're the overarching national institution, therefore if you raise money, that money would belong to us unless you had spelt out to the donors that you intended to start a new charity. And what the judge is finding effectively at paragraph 71 does it says, well, no, that is looking at it through the wrong end of the telescope. You didn't have to spell out that it wasn't going to the Dewsbury Trust. What you had to spell out was that it was going to the Dewsbury Trust. Just 2 more points on this before I move on. First, none of this is based on Mr. Mohammed's evidence. So even if you accede to ground through, you say, well, the judge should have rejected Mr. Mohammed's accounts of the 1994 meeting, you still have this baseline. And second, when I complain about island hopping, this is what I'm talking about. There is a lot of evidence here that takes you to this important passage in the judgment. What does Mr. Holland do? He jumps straight over all of it and starts with the 1994 meeting. That is exactly the point Lewison, or Justice Lewison, is talking about when he talks about island hopping. So, the next passage of judgment, which is paragraph 72 to 85, deals with the inception of the fundraising and the 1994 meeting. And can I just identify the evidence that contextualises that meeting? The first context is that the London community had taken the decision they needed a larger site and they wanted to buy one. It had not been instigated by the Dewsbury Trust. That's dealt with in paragraph 72 of the judgment. Second piece of context. Permission was sought from the Dewsbury elders to go ahead and try and buy the site. But the judge rightly held that that didn't imply the Dewsbury Trust was going to own it. That was to do with the cultural expediency within the movement. That's judgment paragraph 74. Third, that there was no question of the funds being raised in Dewsbury. Hafiz Patel had told the London Shura the funds were to be raised in London and not elsewhere. That's paragraph 73 of the judgment. Fourth piece of context is the evidence about the request for a bank guarantee. Can I just delve into this a little bit? If you take up volume 1 and go to tab 10, you have an affidavit from a man called Mohammed Hafiji. And he didn't give oral evidence because he was too unwell. But he was a man who was a trustee of the Dewsbury Trust at the time of all of the relevant events. And if one goes to page 98 of the bundle and look at paragraphs 7 and 8, you'll see his evidence about the London brothers approaching us, and by us he means the Dewsbury trustees, wanting them to act as guarantors for their purchase of Abbey Mills. He said they had an internal meeting about that and decided to refuse assisting, as we did not want any liability on our Dewsbury trust if the London brothers were unable to pay for the sale. Now, I took that up with Mr. Daji in evidence. If you close up volume 1 and take up volume 4. It's tab 169, page 944. And it's internal page 601, beginning at the bottom there, line 23. So I've taken him to Mr. Hafferty's affidavit, and I read him paragraphs 7 and 8 that I've just shown you. And I asked him, that is an accurate account, is it not? Answer, yes. I checked, was that a yes? Answer, yes. So I moved on. So this account, the account of the bank guarantee, is evidential common ground on both sides. And that is, of course, completely inconsistent with the proposition that the Dewsbury Trust was buying the land. Because if the Dewsbury Trust was buying the land, why would they refuse to guarantee their own performance of the contract? They'd be liable on it anyway.
Well, they wouldn't. I mean, if they weren't the contracting parties, it would be the trustees who were liable.
Yes, sure. But the essential reason why you would refuse a bank guarantee is if you believe that somebody else was buying the land and you just want to. And who is that somebody else there? You say quite obviously, the London community. So that's the context. We then get to the November 1994 meeting, and the judgment deals with that paragraphs 78 to 85. And I will come back to this briefly under ground 2 when I get to the grounds, but again, I just want to identify a number of things about the evidence on this. The first thing to understand is the meeting clearly happened. It's the Holland accepts. Lots of witnesses were called, either attending the meeting or hearing about it. The judge addresses that in paragraphs 79 and 80. I think 18 of our witnesses mentioned it. And Mr. Mohammed's account was consistent with those other accounts. Secondly, Mr. Mohammed wasn't cross-examined about it. I do not accept that the excerpts from the transcript that you have shown amount to any meaningful or proper challenge to Mr. Mohammed's account of that meeting. Thirdly, the judge says at 81 of the judgment, Mr. Mohammed's evidence about the meeting is plausible in context. Plausible in context. And what he means by that is that what Mr. Mohammed describes as having happened at the meeting is exactly what you would expect to have happened at that meeting, bearing in mind all of the broader context that takes you to para 71 of the judgment, and then the more narrow context of the trip to Dewsbury, the request for permission, and so on. The fourth point about the meeting is the controversy about £100,000. That is what, on Mr. Mohammed's account, and as the judge held, caused people to seek reassurance at the meeting that the money wasn't going to be given away to the Dewsbury Trust. And the references in Mr. Mohammed's evidence, just to give you that, it's volume 1, tab 2, page 17, paragraphs 1.32 to 1.40.
1.32
to 1.40. That's his account of the £100,000 being taken. Now, on that evidence, Mr. Mohammed was never cross-examined to the effect that the controversy around the £100,000 was untrue. So it's not just that he wasn't cross-examined about his account of the November 1994 meeting, it's that he wasn't cross-examined about the important bit of context to that meeting either, which is this controversy. And on the defendant's side, no evidence was led to challenge that controversy about £100,000. That could well have been done because lots of Dewsbury trustees were called to give evidence. And indeed, Mr. Mohammed's account of the controversy involves D10. D10 is one of the actors. And D10 gave evidence at trial, and he was asked no supplemental questions about whether he agreed or disagreed with the £100,000 controversy. And then when it came to closing, Mr. Westwood, Mr. Loveday did not submit to the judge that he should reject the evidence about this controversy. There was a general assertion that the recollection of the claimant's witnesses was unlikely to be helpful. That's para 25 of their written post. But that was it. And then on this appeal, there is no challenge to the existence of this controversy about £100,000. Again, all of that is important because the £100,000 controversy is another of the things that makes Mr. Mohammed's account of the November 1994 meeting plausible. The fifth point is that Mr. Mohammed's evidence was that it was decided at that meeting that the land would be transferred into the names of C1, C2 and D14. Now, if, in judging this case, you, or the judge below, accept that, then that is enormously important. Because if the land was being bought by and for the Dewsbury Trust, you would expect it to be transferred to the trustees of the Dewsbury Trust. Why would it go to C1, C2 and D14? And the judge rightly considered that to be a very important piece of evidence. He deals with it at 84 and 85 of the judgment. Now, you will recall when we looked at the pleadings yesterday, the defendant's pleaded case was they didn't know why title had gone to C1, C2 and D14. They said it's for reasons unknown. That's Core Bundle, tab 18, page 260. But when it came to the evidence, it shifted a little bit. Can I just show you how it shifted? If you take up volume 1 and go first to tab 12, page 137, we have a statement of Mohammed Ishaq Chowdhury. And if I just ask you to read paragraph 7 of that statement. What he seemed to be saying is that this was, in some sense, a deliberate decision. I agree, it's slightly ambiguous, so I took it up with him in cross-examination.
So just remind me, so Mr. Chowdhury is...
He's one of the defendant's witnesses. I can't recall whether he's a trustee of the Dewsbury. He is a trustee of the Dewsbury Trust. Right. Sorry, I can't...
The elders asked him to be involved because he was an electrical engineer.
Yes, he was sued as a trustee, so yes, he was one of the trustees.
So he's a Dewsbury trustee and was at the relevant time.
So just put volume 1 to one side briefly, we'll come back to it in a second. But take up volume 4 in the transcript. Go to tab 169. 969. And could you go, please, to internal page 700, line 25. So it's the last line on internal page 700. And could you read down to the bottom of page 701?
Yep.
So I'm talking to him about that paragraph in the statement.
So just the bottom of
Yeah, just at the bottom of page 701. Yes. We need to go further. So what he's saying is, well, the intention on the Dewsbury trustees' side was for the land to go to C1, C2 and D14, and then to be transferred on at some later point. And what we said about it, we couldn't understand why you would do that. That's him. Could you just go back to volume 1, please? There's another witness who touched on this, and it's Mr. Chowdhury, who is volume 1, tab 12, page 137. Again, oh sorry, no, I didn't want to. So sorry, Mr. Rahman, where I want to go. It's tab 18, page 182. Mr. Rahman, I think, wasn't a trustee. He was one of the defendant's witnesses. And if you look on page 182, paragraph 8, just the first sentence, it says, the land for the Abbey Mills site was purchased in the name of C1, C2 and D14 because Hafiz Patel was too elderly to travel to London regularly. And I took that up with Mr. Rahman in cross-examination. Close volume 1 now, go back to volume 4. And we need to go to tab 170, page 978. And it's internal page 735. I'm just going to start at line 18. At paragraph 8, in the first sentence, you say the land for the Abbey Mills site was purchased in the name of C1, C2 and D14 because Hafiz Patel was too elderly to travel to London regularly. Are you sure about that? Answer, as far as from my understanding, there's lots of things need to be done, so he was unable to come regularly, so he gave responsibility to some individuals. But why did he need to travel to London in order for the land to be purchased in his name? Well, those days everything was not very convenient. Like today, you see everything on screens, anything you have to see, you have to come and check. This is why he thought, okay, this is the people who will do the job. He told you this, I've heard this, you heard this in Mashwara. Did you also hear what the other witnesses have said, which is that, say again please, did you also hear what the last witness said, which is that once, that's Mr. Chowdhury, which is that once it had been transferred into C1, C2 and D14's name, then it would be transferred on to Hafiz Patel's name. At that time, I did not hear that. So where you land in all this is that when it came to the evidence, they were saying, yes, it was meant to go to C1, C2 and D14. They advanced different and slightly conflicting accounts of why that was to be. And what we said in our closing, it's paragraph 42 of our closing, so that's tab 162, page 671. We said, once you discount those explanations aren't credible, then the only explanation you're left with is that the intention was to transfer it to C1, C2 and D14 because it was intended to belong to the London Trust. And that submission is a submission the judge is dealing with in paragraph 85, when he talks about this being an important feature of the case. So that takes you to the end of that section of the judgment. The next section is in paragraphs 86 to 88. It's about who raised the funds and who were they raised from. Now, as you know, the BMW defendants, their case was the property was to be a national and indeed international flagship centre. And consistently with that claim, their evidence was that the funds were not raised locally in London. It was that they were raised nationally and indeed globally. And that position was maintained even in closing. The judge obviously rightly rejected that evidence. And he held that the money, or at least virtually all of the money, came from the London community. The next section of judgment said what donors were told. That's paragraphs 89 to 96. Now that's the receipts. I'm going to do a bit of island hopping of my own. I'm going to hop over that at the moment and come back to it in the grounds and here. So we need then to go on to the next section of the judgment, which is paragraphs 99 onwards. And this is where he deals with the correspondence around the acquisition of the site and Mr. Mohammed's dealings with Forsyth's solicitors and others. So this is essentially all the material to do with Mr. Loveday and Mr. Holland's Occam Razor point.
Just so I understand, you're now dealing with 99 through to
142.
yeah.
Now, the starting point for all of this is Mr. Mohammed, who instructs solicitors. He instructs Mr. Isaac Forsyth. They have been his family solicitors. None of the Dewsbury Trusts ever at any point had any contact with Forsyths. I'll give you a reference to the transcript on that. It's volume 4, tab 169, page 952, internal page 634, lines 20 to 25. And one of the earliest documents we have, and one on which Mr. Holland relies, you take up volume 1 of the Bible, go to tab 35, page 283. It's Forsyth's writing to Grimley in February 1995. Grimley are the selling agents, what became Grimley GBA. And he says, Mr. Ockeye, just pausing there, sorry, it was asserted by Mr. Holland yesterday that Mr. Ockeye was a fictional character. He most certainly wasn't. He's a real individual. He was involved with a company called Merry Maid, and I searched the transcript. There was no suggestion at any point in any of the evidence that Mr. Ockeye was an invented character. He now wishes the purchase to proceed in the name of Anjuman Muslim of the UK. This is the largest of the Muslim charities. And Mr. Holland relies on that as evidence of the effect that Mr. Mohammed must have said to Forsyth that the purchase was the Dewsbury Trust. Now, what the impression, against Lord Houghton's biogen, the impression that the evidence made on the judge was that this letter had been written, indeed some others had been written, to reassure the people with whom Mr. Mohammed was, people from whom Mr. Mohammed was seeking to buy the property, or with whom he was seeking to deal, that they were dealing with someone of substance, because he was concerned they wouldn't otherwise be. And that there is a discussion of that with Mr. Westwood in closing. I won't take it, but I'll give you the reference. It'll be volume 4, tab 173, page 1004, internal page 978, line 7 to 979, line 3. That's when the judge discusses that possibility with Mr. Westwood. And where the judge lands on this, in paragraph 104, where he makes a finding that this was indeed about reassuring Grimleys. Now, very quickly after that letter, things move on, because in volume 1, if you take up tab 42, page 298, so this is a few months later. And it's Forsyth's writing to Mr. Mohammed.
Sorry, tab.
Tab
You said
42.
42.
42, page 298.
Yeah.
So 16th of May 95, Forsyth to Mr. Mohammed. He's covering various matters. But the important one, present purpose, is the fourth paragraph. Meanwhile, would you please confirm the purchases are properly described as Anjuman Muslim? The response to that letter has not survived, but we know that there was a response to it, because if you go to the next tab, we have another letter from Forsyth, a week later, 23rd of May, again to Mr. Mohammed, saying, thank you very much for your letter of the 18th of May. That's the letter that's missing. He says, I'm grateful to you for letting me have the precise description of the purchases. So what happened is between 16th and 20th of May, in fact on the 18th of May, Mr. Mohammed wrote back to Forsyth giving him a precise description. And we see in this letter of the 23rd of May that Forsyth had asked for an address for the purchaser for insertion into the contract. Now, we don't have a copy of the executed contract, that does not survive. But we do have a draft of the contract. It is in your volume 1 at tab 57, page 320. Now, it is dated, you'll see at the bottom. So, well, you see a number of things. So it's prepared by Apothecary and Appellant. They were the vendor's solicitors. And you'll see right at the bottom there's a date, the 7th of August 1996, much, much later. But as you will see in a moment, in fact, this document had been prepared far, far earlier than 1996. It had been prepared in the middle of 1995. And if you go over the page to 321, you will see how the purchaser is described. It's Anjuman Lahore Muslimin of London, UK. And the address that's given is not the Dewsbury address, but the Christian Street address in London. And what we submitted to the judge and what the judge accepted...
Just to be clear, when you say not the Dewsbury address, it is an address of the Dewsbury premises.
Correct. But it's not the South Street Dewsbury address, where the Dewsbury Trust is headquarters.
Where does the document at page 318 fit into that? Because that's dated the same date, but doesn't have the London insertion.
I don't know. I'm sorry. And I can't remember there being evidence about that particular point of trial. I'll ask my junior just to rack his brains in case he can recall.
I mean, what one sees there is a correction to the name. So someone has obviously been provided with a draft with the name incorrectly spelt, suggested the amendment.
Yes.
Although there's another amendment, it's not been put in the manuscript if you compare the two.
Yes, because there's London, which doesn't feature in the it does feature in later. At any rate, if one goes back to supplemental on tab 44, page 300, we can see that as at the 6th of June 1995, they were about to be ready to exchange contracts. He says, we'll be writing to you fully in the next few days with the contract for signature. And then after that, for reasons that have to do with title complications and some survey results, everything basically ground to a halt for quite a long time, until a point in 1996. And if you go to tab, in the same bundle, tab 58, page 330, we jumped right forward to September 1996. Mr. Isaac writes to Mr. Mohammed saying, here now is the contract for the purchase of this property from Western Properties Limited. And he says, this should be signed by someone with authority within your society at the foot of page 8. Please then return the contract to me as soon as you can with a cheque for the deposit. Now, we know that the society at this point must be a reference to something that's described as Anjuman Muslimin of London, UK, because we've seen the contract. And there was no evidence to the effect that in response to this letter, C1 or anyone else sought any authorisation from anybody at the Dewsbury Trust in order to execute the contract on the Dewsbury Trust's behalf, as they would have done if Mr. Holland's right and they thought that they were entering into the contract on behalf of the Dewsbury Trust. And we said the correct inference to draw from this is that they didn't think they needed any authority from the Dewsbury Trust because they weren't executing the contract on that trust's behalf.
Do we have the attachment to the 18th of September letter, so we don't know which of those contracts was attached to it.
No, except that we do know, well, no, but we can work back from the transfer. I'll show you in a moment. So, tab 62, page 338, we see contracts have now been exchanged. Eureka! Contracts were exchanged this morning. It's taken a long time. Contract provides for completion on the 5th of November. And then says, third paragraph, the property will need to be purchased in the names of trustees for the society. So perhaps you would let me have the full names and addresses of those trustees. Now, again, we don't have the reply to that letter, but we know exactly what Mr. Mohammed must have said, because he was asking for that information at this point in order to complete the transfers. And the transfers do survive. The contract doesn't, the transfers do. Transfers at tab 69, page 354. There are a number of them because there were various different title numbers, but they're all the same. You'll see on page 354, the transfer is to Zulfikar Ali, Ibrahim Ahmed Sheikh, Solid Sikandar Mohammed, brackets, trustees for Anjuman Islam Muslimin of London, UK. And that is what has subsequently gets entered on the Register of Title. Although for reasons I'll explain, title registration is not completed again for another couple of years. So that takes us up to the beginning of November.
Now, you've obviously jumped over correspondence that Mr. Holland relied on the apparently Dewsbury paper.
There are, yeah, I mean, we accept it in front of the judge, obviously we did, but there are documents when, which Mr. Mohammed wrote, which had elaborate letter headings on them, which referred to the Dewsbury Trust. But, we said, it's clear from the correspondence that I have shown you that when they focused on who the identity of the purchaser was to be, the instructions that were given to Forsyths were clear. They couldn't have been anything other than that the purchasers are these three individuals as trustees for the London described trust.
I mean, that seems to be clearly the case in late 1996. It isn't so clearly
exactly
the case.
When it happened. I mean, we would say it happened some point in 1995 because the name with London in the name ends up in the contract. So we say that it probably happened then, but I agree, there's no conclusive evidence when exactly it happened. The completion was fixed for 5th of November. There was then an event on the 2nd of November of some importance. And what happened is that a fax was sent. And the fax is at tab 66 of volume 1. Volume 1, tab 66, page 343. And the fax itself is a document on page 343. It's written in Urdu. 344 is a translation prepared, I think, for the purpose of the trial. Well, it may have been prepared earlier, I'm not sure. But anyway. So you'll see what is said there. It says, this was a fax sent to D14. Peace be upon you and mercy be upon you. You're requested to go to the lawyer on Monday and enter all the names listed below in the new deed which is about to be made for the new place, so that some of them may come on Tuesday and sign with you in person. Keep these names to yourself. Now, this fact comes in a context where, as I showed you in relation to Mr. Chowdhury's evidence and Mr. Rahman's evidence, the Dewsbury side intended that the land was going to be transferred to C1, C2 and D14. I mean, they said as a sort of stopgap, and it would then go on. But now there's a change. Something has shifted in the mood, and they don't want that to happen anymore. They want it to be transferred into the names of 10 people who are all trustees of the Dewsbury Trust. And the explanation that we had for that in the evidence came from Mohammed Haffiji, who's the chap who's one of the trustees of the Dewsbury Trust. Can I just show you what he said? It's Volume 1, Tab 10, page 100, paragraphs 9 to 13. If I could ask you just to read that to yourselves, please. We'll close that up, just take up volume 4. I took this up with Mr. Daji. And you need tab 169, page 950. It's internal page 627, line 23. I've taken him. Actually, it starts at line 19.
So which page bundle is it?
So, bundle page 950, internal page 627. And line 19, you see, I take him to Mohammed Hafiji's affidavit. I took him to paragraph 10, 11, and 12. And you'll see at line 15, I said, he's right about that, is he not? In what he says there, meaning what he says in those 3 paragraphs, to which the answer came back, yes. Now, what we said all of that told you was 2 important things. First, that contemporaneously the Dewsbury trustees did not understand themselves to have been the rightful purchasers of the land. And secondly, as importantly, they understood that the donors had given money in the belief that the property was going to be held by and for the London community, and that if the Dewsbury Trust took the title from them, that they may think that the land was, or would think that the land was being stolen. Completion happened on the 5th of November. In fact, there was no response to that fax, and none of those 10 trustees did come to London. The next event is that Mr. Daji instructed solicitors, Chadwick Lawrence, to write to 4 sites on the 13th of November 1996. And that is the letter, tab 71 of volume 1, tab 71, page 369. In which he asserts that he acts on behalf of the Dewsbury Trust. He asserts that they provided the purchase money in respect of the property. It is nominated 4 trustees. Please arrange for an amended transfer. Referring to an amended transfer, it shows you that the Dewsbury trustees understood at that point that the existing transfers were not to the Dewsbury trustees but to somebody else. What Mohammed Hafiji said about that letter is in paragraph 14 of his statement. It's the same volume, back on tab 10, page 100, paragraph 14. I'd perhaps ask you to read that to yourselves.
Yes.
Now, Forsyth did not reply to that letter straight away. More than a month passes. They finally respond on the 17th of December 1996. It's volume 1, tab 73, page 372. It's important to pick up the nuance in this letter. It begins, it's Forsyth's writing to Chadwick Lawrence. A month has elapsed from Chadwick Lawrence's letter. First of all, please accept my apologies for the delay in responding to your letter dated the 13th of November, but I have wanted to check the whole situation with Mr. S.S. Mohammed, from whom my instructions have come from the outset, he, of course, being the Secretary of the Association. He then goes on to say, to effectively accede to Chadwick Lawrence's demand. Now, the implication in the first paragraph, we say, is striking. What it's the implications? Well, what he's been told by Chadwick Lawrence does not accord at all with his understanding up until that point. That's why he didn't respond straight away. He wanted to go off and check the whole situation with Mr. Mohammed. What he's being told is something that conflicts with his previous instructions. And the judge, that was what I submitted to the judge, and the judge agreed with that submission. He is reading paragraph 121 of his judgment. The other thing that's evident from this is that he goes on to say he will prepare fresh transfers. He wants to have the names of the addresses of the Dewsbury trustees. So the other thing that's evident from this letter is that Mr. Mohammed, presumably C2 and D14 as well, have instructed Forsyths to transfer the land to the Dewsbury. And what the judge held about this is, take up the core bundle. Tab 10, page 173. I ask you to read paragraph 122 and then the first two sentences of paragraph 123. It is at this point in the narrative that you get the business rates relief application, which is tab 82. That's one of the tab 82 of volume 1, I should say, the supplemental bundle. That's, I think it's about 5 months later. That's one of the documents on which Mr. Holland relies. Now, in this chronology, at this point in time, there's nothing particularly sinister or surprising or informative about that, because at this point, the intention was that the land was going to be transferred to the Dewsbury Trust. But then, in around late 1997, you have what C1 described as a breakdown in the willingness of the London community to work together with Dewsbury Trust and transfer the land. And the explanation for the breakdown is that the Dewsbury Trust sought to get permission from the most senior elders at Nizamuddin for the site to be sold. And as you can imagine, that would not have gone down well. The London community had spent years raising funds. They finally managed to acquire this site, and the next thing that happens is the Dewsbury Trust go up to Nisbeten to get permission for the land to be sold again. And the judge deals with this in his judgment at paragraphs 128 to 129. I don't think we particularly need to go there. There's no challenge generally. But he says he accepts that there was a breakdown in the relationship, except it was likely to have been...
Can you go to, it puts in context that is the first sentence of paragraph 128.
Should we read?
Read 128 and 129, so I don't want to be partial. So page 177, read 128 and 129. Perhaps while we're here, if you would read on to 130 as well.
Yes.
So it's at this point that the instructions to Forsyth change back, as it were, to the original position, which is register the transfer to C1, C2 and T14. And just to complete the run of correspondence, you go back to volume... volume 1, tab 96. 44.
Forty-four is tab 95.
Tab 90, I'm so sorry, tab 95, 44. That's what I wanted. That's Mr. Mohammed to the solicitors, Mr. Isaacs. Very hot issue. Please leave other solicitor aside, but we must register as soon as possible. And then next tab, tab 96, you have 30th of June 1998 letter, Mr. Isaac back to Mr. Mohammed. Fourth paragraph and fifth paragraph. The property does belong and has long since belonged to your association, so there's nothing to prevent you putting in an application. Planning consent. I shall be in touch with you again as soon as I hear from the registry. Meanwhile, a week or so ago, I had a telephone call from Mrs. Chadwick Lawrence, and I told them my instructions were to proceed now to register the title without alteration to any of the transfers. So the people in the north do now know what we are doing down here. And then if you just go on to the next tab, this is the office copy entry with an addition date of the 2nd of July 1998. And if you look at the proprietorship register on page 428, you'll see that the date in brackets, start of paragraph 1 is 2nd July 1998. So that is the date of the application to the land registry, because as you know, when the proprietorship register changes, it backdates the date of the application, and the date that's inserted there is the date of the application. The final leg of the story concerns the set of documents on which the defendants placed enormous reliance, which you'll find in volume 2. And the first set is at 105, page 447. And you'll see there are a series of typed documents in which Mr. Mohammed and Mr. Sheikh, but at this stage not Zulfikar Ali, confirm that the property is held in trust for the trustees of the Dewsbury Trust. They declare a preparedness to execute a transfer of the property. And then there are some pre-prepared and signed instructions to Mr. Edward Isaacs misspelt, four-sided solicitors misspelt, pages 449 to 450, reportedly instructing him to transfer the property to the Dewsbury Trust. But those documents date from October 1998. Then another very similar set of documents, which you'll find at tab 108, page 455, which date from January 1999. They're very similar in substance. They contain confirmations that the property is held for Dewsbury Trust, declarations of a wish to execute an immediate transfer, and a statement that they're going to instruct, again misspelled, Mr. Edward Isaacs, to effect immediate transfer. And our evidence about those was simply that they were documents that were presented to us pre-prepared, as it were, at a mashwara in Dewsbury, or two mashwaras, one in 98, one in 99. And we were told to sign them by Hafiz Patel. And we felt we had no option but to do so. But the fact that we signed them did not reflect that we believed to be a true position, and we never acted on them. In other words, although we execute these documents saying we're going to instruct Mr. Isaacs to transfer the land, we never did instruct Mr. Isaacs to transfer the land. And the judge agreed with that submission. The relevant section of his judgment is paragraphs 181 to 183. Actually, can I just ask you to take those up briefly? So, Core Bundle tab 10. Pages. I gave you the wrong paragraphs. It's page 181, paragraphs 1 through 4. No, that's wrong again. Sorry, page 179, Core Bundle, tab 10, page 179. It's paragraphs 134 to 138. And can I just direct your attention to the last two sentences of 138, where he says, we considered the evidence. This only makes it all the more clear that they did not genuinely accept that the property was held for the Dewsbury Trust, and that their expressions of willingness to effect a transfer to it were reluctant. I accept C1's evidence to be reported back to the London community, which again was very upset and did not want the land to be transferred. The final two documents I want to show you are in volume 2, and they are at tab 142. First of the two documents, tab 142, page 528. And just to give you the context for this, C1, C2 and D14 had entered into a Section 106 agreement with Newham Council, and an injunction had been obtained against them. I'm not sure exactly what the injunction was, to cease use of the site as a place of worship at this point. And what had happened is that Newham Council had obviously gone to the Charity Commission and typed an Anjuman the Islam Muslim, and it had brought up the name of the Dewsbury Trust. And they had thought, oh well, the Dewsbury Trust is the one that we should be dealing with in relation to this. So this letter, which was addressed to Ibrahim Sheikh, the Markazi Mosque at South Street, Southtown, Dewsbury, asks the Dewsbury trustees to consent to be joined to the proceedings. And you see that paragraphs 8 to 11 on page 4529. I think what they thought was that the composition of trustees had changed since the injunction was issued. So they're asking for consent to be joined, and what happens is the Dewsbury trustees instruct solicitors Kingswell Watts, and they write the letter at tab 143, page 530. Dear sirs, we've been instructed by Shabir Daji, Mohammed, Boston, etc. We've seen a copy of your letter. We confirm that none of our clients referred to above are trustees of Anjuman-e-Islah al-Muslimin of London, UK, brackets the London Trust. The avoidance of doubt, we also confirm they've also never previously been trustees of London Trust. All our clients are trustees of Anjuman-e-Islah al-Muslimin of the United Kingdom, the Dewsbury Trust. The The London Trust and the Dewsbury Trust are separate entities. Our clients have no involvement in the London Trust, and as such they do not consent to being added as parties to the auction. And also that's the end of my survey of the evidence. The final section is to deal with the grounds of appeal. But ground one, I'll deal with them ground 1, 2 and 3. Ground 1 is the receipts. As my Lord Justice Arnold said, if the receipts were a trustee and we were being asked to construe them, the appellants would win this case. One question. But that's not the question. The significance of the receipts is only in relation to the inferences you can draw from them about what the donors intended. And in order to answer that question, one of the first points you have to keep in mind is that these are not documents that were presented to potential donors for the purpose of soliciting a donation. They are documents that are given out to somebody who has already decided to and has already made a donation. The way I put it to the judge in closing was you don't donate money because you're given a receipt. You're given a receipt because you have donated money. Now, the judge had to evaluate these documents. He was not doing this in an evidential vacuum. There was, I'm going to call a broader evidential context, and there was a narrow evidential context. The broader evidential context is essentially all of the material that I've discussed at length in the last section of my submission. There's the structure to legally demand and the baseline, what I call the baseline expectation. There's the fact that the decision to buy the property had been made by the London community to serve the needs of the London community. There's the judge's findings about the November 1994 meeting, and I'll come on to explain why we say the judge was plainly and obviously entitled to make those findings. We have the context to do with the financial tension between the two communities arising out of the incident involving £100,000. We have the evidence about the intended identity of the purchasers of the land being C1, C2 and D14 and not trustees of the Dewsbury Trust, and that being common ground. The fact of the funds being raised from the London community exclusively and by the London community, and the way in which C1 instructed solicitors that the purchasers were C1, C2 and D14 belonged on a London Trust. That's a lot of important context. And again, none of that context, or very little of it, depends on the evidence of Mr. Mohammed. That's the wide context. But the narrower context is that there were quite a few references in the evidence to receipts. I'm happy to take up volume 1. I just want to show you some of these. So, volume 1, tab 1, page 8. So this is one of my witnesses, Mohammed Rahman. In paragraph 6, he gives his evidence about the November 1994 meeting. Paragraph 7 and 8, he says he was involved in collecting money from relatives and friends. He collected about £10,000 in cash in total. He says he personally donated his wife's gold necklace.
I'm sorry, I think I must be on the wrong page. Can you give me the page again?
Page 8 had paragraph 6 on it, which I skipped over. That gives evidence about the November 1994 meeting. And on page 9, I'm looking at paragraphs 7, 8 and 9 now.
Thank you.
He's involved in collecting money from relatives and friends, etc. Paragraph 8, he personally donated his wife's gold necklace. I gave the necklace to Abu Salah, who is a London brother. Since the purchase, I've given several small donations and also loans because more money was needed after the purchase. All loans were given receipts. My children have also given cash. Paragraph 9, I recall that the elders of London Shire appointed 3 trustees to purchase the land. I would have objected to Abbey Mills being transferred to Dewsbury. Two things to notice about this, if you will. First, he clearly remembered giving out receipts. He's not trying to conceal that fact. And in his mind, quite obviously, the receipts were not inconsistent with the position he states in paragraph 9 that he would have objected to Abbey Mills being transferred to Dewsbury. Now, this is the point that the judge makes in paragraph 96 when he talks about the witnesses referring to the receipts without embarrassment. Sorry, I said 2 points, only 1 point.
Sorry, what was the reference in the judgment?
Paragraph 96.
Yeah.
Could we go on to the next tab, please? Tab 2. Tab 2 is the statement of Mr. Mohammed. Now remember, this is the man who was castigated on this appeal as an inveterate liar, willing to mislead on all and every front if it will serve his purposes. And page 22 of the bundle, paragraph 519, he talks about giving out receipts. He says, say for example, I'm in South London, the mosque there is called Streatham Mosque. They're the local people who know I'm going to the Markaz, they give it to me, and I go to the Markaz and give it to the 3 people looking after the money. And if they want a receipt, I'll bring the receipt for them, because the loan receipt is very important. Now just notice from this, again, as with the previous statement, he talks about receipts are given out for loans, they're not given out for donations. We go on to tab 6, please. Page 68. Find the statement of another of my witnesses, Shukat Malji. And if you go to to page 71, paragraph 18, then whatever the local brothers raised, they brought it to us, they brought cash, they brought checks, they brought money. I'm not aware which bank accounts the checks were paid into, I was not responsible for dealing with the money, that was done by another London brother. Where loans were given by whoever from the locality, the London Shura gave them the receipts to prove that they've got a loan here. A loan diary was also kept recording the loans made. A few people recorded the loans in the diary, although the majority was done by Solad. Again, no embarrassment about the receipts, entirely matter of fact. And then page 72, paragraph 71, I've not kept records of the donations, unless specifically requested. The Shura would not give receipts for donations. Receipts were given for loans as proof of the loan. That's important, because it's not necessarily obvious from the previous statements, but it is obvious from this one. The purpose of the receipt is not to tell you who you've given your money to. It's to give you proof that you've made a loan. So that when you want your money back, you turn up with your piece of paper with a number on it, it's cross-checked against the loan book, and you can then get your money back. Go on to tab 7 in the same bundle. Page 78 is a statement of Nasir Cadwallader, another of my witnesses. Page 80, paragraph 10. Although I asked for loans, people also gave donations, whatever they could afford. Both the loans or donations were either cash or cheque. If it was a loan, I'd take this to Ghulam Patel, he would give me a receipt, and then I would give the receipt to the person giving the loan. Again, perfectly matter of fact, no embarrassment, and the receipts related to loans. Can I just show you 2 points in the transcript? So it's post volume 1, it's volume 4. And first we want tab 164. Page 825. And if you look at internal page 116, line 5, of course, all the money was given to Ghulam Patel, who was at the time in the Markaz, and he has record right down in his book. That person had £2,000, he gave me a receipt as well. Those who collected, the receipt he was giving to them, along with the, something unclear, so over there. The loans and so much, we returned them as well afterwards when they were required. It used to come to me that I had a loan to such and such, can you please lend me such money? So I used to go to our elders and requested that so-and-so were requesting some money back. Is it possible? They always used to oblige. After a week or two they used to manage, I tell you what to do, so I'll come back and give you your money. And then page 118 internal, lines 17 to 24. You say notwithstanding that you raised more than £50,000, more than £50,000. So many people did not want the receipt. They say they just give the money and they do not want a receipt. That could be one of the reasons. If they ask for a receipt, we give them a receipt. Those who just want to donate generously, we want to be discreet. It's between me and Allah. It was not compulsory that they take a receipt. So many just donated out of good heart. And then finally, Lords, tab 167, page 881. Internal page 343. So this is one of my witnesses, Yaqub Ali Mohammed, cross-examined by Mr. Westwood. Just line 3. Mr. Mohammed, you say you donated £1,000. You still have, that you kept a record of the payment. You still have that record. I believe at the moment I don't have a record. No, but I have been given a receipt. Judge Cadwallader, I'm so sorry. Could you say that again? I donated £1,000. At the time of the donation, I did have a receipt. I don't have it right now here. Judge Cadwallader, thank you. Mr. West, you attended Christian Street prior to the purchase of Abbey Mills, is that correct? Yes. Were you aware that Christian Street was owned by the Duty Trust? Yes. When you make your donation, were you told at any time the new site was going to be independent from Dewsbury? Yes, I was informed. And who told you that? The committee members, because I asked the question before I donate a payment. Which committee members told you that? If I remember correctly, Mr. Sokat and other people. Did they tell you they were establishing a new charity? No. Did you ever see a new charitable trustee in relation to the property? No, I did not have that knowledge at that time. No. What I'm going to suggest to you, Mr. Mohammed, is that nobody told you that Abbey Mills was going to be independent from Dewsbury. Do you accept that? Answer, no. I asked them, this new markethouse, the new place that we were buying, will there be any connection with Dewsbury? They said it's totally independent. On that basis, I have donated £1,000 for myself. I have no further questions, my lord. So, he recalled getting a receipt, but he also, at the same time, believed and had been told that the new markethouse was going to be independent from Dewsbury. Now, we submit that in all of that broader context and that narrower context, the right conclusion, at least the conclusion that the judge was perfectly entitled to draw, was that the donors had not attached significance to what was printed on the receipts. Can we just take up the judgment now to see how the judge dealt with this? So it's tab 10, and it's page 157. Paragraph 89, he refers to the claimant's witnesses and the evidence that they gave. At the top of page 158, there's a sentence in the judgment that Mr. Holland criticises, where the judge says, none of them, that's the claimant's witnesses, indicate on whose behalf the receipts were given, and it's natural to assume that they thought they were given by or on behalf of the London Shire or London trustees, as indeed they must have been. Now, there are different ways of reading that, I think we mentioned yesterday. Maybe that my Lord Justice Arnold's way is right. I think for my part, I probably read it the way Lord Justice Newey did, and that what he was saying is that the receipts were in fact being given out by C1, C2 and D14, the people they'd appointed. And these are all witnesses whose evidence was they believed that the money was going to London trustees for a London trust. And so when he says, well, it's natural to assume they thought they were being given on behalf, that's because that was their position, as it were. They didn't think it was going to Dewsbury. 90 to 92 of the judgment deals with how the receipts came to be in evidence. 93 deals with the evidence that ties the receipts in to the loan book. 94 to 95 is refers to Mr. Mohammed's evidence when he was recalled and asked about the receipts. So the judge took all of that into account. And then 96 is the crucial paragraph. And the first thing he does is he makes a finding that the loan book came into existence in the 1980s. The reference to London New Marquaz was a reference to an earlier project around finding a replacement for Christian Street. It therefore predated the Abbey Mills project. And it was perfectly plausible, that as my Lord Justice Arnold put it yesterday, the receipts book was used just for convenience. That's how it came to be used. Over the page, he rejects Mr. Mohammed's evidence that he never noticed what was printed on the receipts. But then third, he says he accepts that no one ever raised a query about it. Then he talks about the fact that it mattered to the London Shire and the London community that the property was to be held by the London community and not by the Dewsbury Trust. And that's by reference to all of the evidence that I've canvassed in front of you today and yesterday. And in the light of all of that, he holds that they did not regard the reference to Dewsbury on the receipts as being of any significance, because if they had done, they would either have sought the assurance or there would have been controversy. And neither of those things occurred. So for that reason, he concludes, he doesn't consider that it proved that the London trustees regarded themselves as agents for the Dewsbury Trust, or that they proved something about the intention of the donors. And then finally he goes on to say it's not insignificant that defendants placed no reliance on them until very late on in the proceedings. And that he's criticised for that, but it wasn't insignificant. The defendants had 28 witnesses of fact in this case. And not a single one of those 28 witnesses mentioned the receipts in their witness statement. 2 of them did in cross-examination, but not one of them in their statements. And what that showed you was that the 28 people who the defendants had proved to give evidence, when they were being proved, did not record having attached any significance to the receipts. Because if they had done, they would obviously have mentioned it. My Lord, we say, in all of that context, is this a conclusion that no reasonable judge could have come to? We say, obviously no. A reasonable judge could perfectly well reach that conclusion. Indeed, we say it's the right conclusion to reach. The only other point on this is just to remind myself and your Lordship of the point Lord Justice Newey made yesterday, which is that the receipt book was still being used in 2012. And at that point, clearly, the London trustees regarded themselves as being distinct from Dewsbury. And so at that point, they cannot possibly have been attaching any significance to what was printed. Well, that's all I wish to say about ground 1. Ground 2 is holding out. And I think, my Lord, that I've covered pretty much all of this in the survey of the evidence. There is the Forsyth's letter saying he was acting for the largest of the Muslim charities. I've dealt with that already. I perhaps haven't dealt with the name on the bank account. If you take up volume 1 of the supplemental bundle, tab 33, page 281. What this document purports to be is a minute of a meeting of the Committee of Management of Anjuman Muslimin of the UK, in which various resolutions are passed, by Zulfikar Ali, D14, as chairman of that society. He was not chairman of the Dewsbury Trust. Ibrahim Sheikh was treasurer. He was not treasurer of the Dewsbury Trust. And signed by Mr. Mohammed, the signature, the second of the 2 signatures at the bottom. That's Mr. Mohammed's signature. He's described there as being the secretary. He was not the secretary of the Dewsbury Trust. So none of those descriptions sit with their position in the Dewsbury Trust, but they do all sit with their roles within the London Trust. D14 was the chairman, Sheikh was the treasurer, and Mr. Mohammed was the secretary. And what we said in our closing about this to the judge is in volume 3, tab 162, page 674. And it's paragraph 47 of my closing.
I think I'm entirely in the wrong place. Sorry, where should I be?
It's volume 3, tab
Yes.
162,
Yes.
page 674.
Yes.
My closing, and it's paragraph 47. And the judge deals with that in his judgment, paragraph 108. I dealt also with the application for rates relief. The only other thing to say about holding out is that it's all very well to point to some documents where you can say, well, look, they were. But there's lots of other documents that go in precisely the opposite direction. And if you're going to do, I mean, Mr. Holland's case as well, look at what they said, that must be true. But he says that in relation to documents that help him. If you say the same thing in relation to other documents, you get completely the opposite answer. So ground two did not help the judge to solve the case.
Just to be precise about this, the document you showed us, the minute,
The
minute of the resolution.
Yes.
You explained to us why, from the persons who drafted that resolution, from their perspective, they were dealing with this on behalf of the London Trust. But the judge at 107 says that the National Westminster Bank account was opened in the name of Charity 505-732. Isn't there some other documentation with the bank which includes the charity registration number? So that, as regards the bank, they were holding out that this was an account of the Dewsbury Trust.
On the factual proposition, you may well be right. I can't recall one, but I sense from the other side of the room that there is something. That may be right in terms of how they present, how it would have presented to National Westminster Bank. But how it would have presented to the bank is not the relevance of this document in the context of what the judge had to decide. Its relevance is, what does it tell you about what C1, C2 and D14 believed was going on?
Well, if they were deliberately, I mean, I think the judge describes this as deliberate ambiguity. So what's your explanation for that? That the trustees of the London Trust, assuming there was one, were holding themselves out to the bank as acting for the Dewsbury Trust. What's the relevance of that in terms of their own understanding?
Well, the ambiguity may come back to the same. I'm not sure quite what the judge meant by the deliberate ambiguity. It may well just come back to the same point that he made about the Grimley letter. It's to reassure the people with whom they're dealing that they're someone of substance. They're allowed to open a bank account proper in that sense.
I mean, it obviously could potentially be rather more damaging to your case in the sense that this is something not long after the November 1994 meeting, and one might therefore, on the face of it, expect what the bank was being told to record.
It was absolutely a piece of evidence on which reliance was placed by the other indicted defendants below. Would I rather not have this in the case? Of course. Yes, but you know that these are fine points of evaluating lots and lots of evidence. And that is supremely the judge's task, because he's the one who lived through this day after day and gained a proper insight into all of it. Well, ground three, that's that the judge should not have accepted Mr. Mohammed's evidence about the November 1994 meeting. I've got six very short points to make about this. First, their findings of primary fact, and so, as per Volpe, the judge's conclusion has got to be rationally insupportable. first point. The second point is what the judge did, in fact, was he directed himself to be careful about C1's evidence. That's paragraph 151 of his judgment. We say he can't be criticised for that approach because it is a fallacy to conclude that because a witness lies about one thing, he must necessarily have lied about absolutely everything. And we give a reference in our submission, our skeleton, at paragraph 37 to the Powell decision, common ground. That's my second thing. The third thing is the fact of the meeting is unquestionable. It definitely happened. The fourth thing, point I made earlier, which is that what Mr. Mohammed said about the meeting was entirely plausible. Indeed, it made perfect sense within the broader context and the narrower context. The fifth point is that there was no meaningful cross-examination about this. And the sixth point, if I may pick up a point my Lord Justice Arnold made, my learned friend, it is not actually very surprising that he had a detailed recollection of this meeting. If you were to ask him, I suspect Mr. Mohammed would tell you that this was one of the most important events in his entire life. He is a devout Muslim and an adherent of the Tablighi Jamaat movement. This is, and Elias. It is at this point in time, when he was put in charge of a massive fundraising exercise to raise money to buy land for a mosque.
£1.4 million worth.
Yes.
Not an insignificant amount of money for anybody.
No. And I'm quite sure that if you were to ask him, he would tell you that this is the most important thing, as a devout Muslim, this is the most important thing he's done in his entire life. And Lord, the appeal does not come anywhere close to the threshold of rational insupportability under ground 3. And Lord, I said earlier, I sensed earlier, yes, that you wouldn't be helped by being taken to the authorities on appeals on fact. Will you just, earlier than I said I would, will you indulge me for one moment? And just go to the authorities bundle tab 7. It's bold. And I'd like to go to page 148, it's the last page of the judgment. Under the heading Conclusion and Result, is Lord Justice Lewison. This appeal demonstrates many features of appeals against findings of fact. 1. It seeks to retry the case afresh. 2. It rests on a selection of evidence rather than the whole of the evidence the judge heard, what I have elsewhere called island hopping. 3. It seeks to persuade an appeal court to form its own evaluation of the reliability of witness evidence, when that is the quintessential function of the trial judge who has seen and heard the witnesses. 4. It seeks to persuade the appeal court to re-attribute weight to the different strands of evidence. 5. It concentrates on particular verbal expressions the judge used rather than engaging with the substance of his findings. And may I submit that every one of those criticisms is absolutely pertinent to this appeal. Well, that's all I wish to say. Help you further.
Thank you very much, Mr. Sefton. Mr. Mohammed.
My lords, I'll start with the last point my learned friend made, and then what I would like to do is simply deal with the points he's made in chronological order starting yesterday. And it's the point he took up, which was made to me yesterday by Lord Justice Arnold, about, well, this is a very significant event, and you might expect Mr. Mohammed to remember it, despite the fact that it was undocumented, despite the fact that it was 28 years ago. Well, I make 2 points in relation to that. First of all, we can all remember significant events in our life. Our weddings, our call night, our silk process. But can we remember detail? We might be able to remember our weddings, two of them in my case, but can we remember the name of the vicar that married us, or what was in the sermon? We might be able to remember our call night, but can we remember the name of the person that called us and the nature of the speech that was given that night? We might be able to remember our silk day, for those of us who have the benefit of that. But can we remember the identity of the Lord Chancellor who gave the speech? And can we remember what was in the speech? So we can remember significant events, but 30 years ago, can we remember the detail, significant detail of what happened? We have broad recollections, but we cannot, in my submission, and that's what the authorities warn the judge against. We cannot remember significant detail, and it's wrong for anyone to suppose that they can. The second point I make is and I'll take it is the Guestman point, is that if you have a significant event and you think it's significant, and it's a long time ago, and it becomes the subject of litigation, that is all the more reason for your memory to play you false. I need to take you to Guestman because it sets it out much better than I ever could. And it's at divider 9, I think, of our authorities bundle. But I would invite you to read the lined paragraphs there, paragraphs 16 to 20. And the point is this, that the very fact that this is, or has now turned out to be, a very significant event, is all the more reason for the tribunal to exercise caution when it's listening to oral accounts, oral recollections of what happened at that meeting, because one's memory evolves over time and gets moulded either consciously or unconsciously.
Is it your submission that the judge accepted Mr. Mohammed's evidence uncritically? And if so, upon what do you found that submission?
Well, my submission is that he accepted this particular part of his evidence. I accept that he was critical of Mr. Mohammed. But we say if one looks at the evidence, all the evidence that the judge had, in particular the bits that I have highlighted, and Mr. Mohammed's evident dishonesty, despite the nature of his apparent religious belief, the judge should not have accepted it.
But there is a tension here, because Guestman says, well, you misremember. But that's not your case. You say Mr. Mohammed is dishonest. You say, well, he's making things up, knowingly.
Yes, but the judge didn't have to. I mean, he was fine to be making things up in other aspects of his evidence, but the judge didn't have to find whether Mr. Mohammed was lying about what occurred at that meeting or not. What he had to say is, well, hold on, Mr. Mohammed has very detailed recollection of what he says occurred at this meeting. Now, meetings occurred, there's no doubt about that. Other evidence, lots of witnesses said their meeting, and again, it's entirely understandable. But what was unique about this was that Mr. Mohammed could remember exactly what he said happened at this, and very significantly what happened at this. And whether he's deliberately lying about what happened, or as he lied about other aspects, or whether unconsciously he's remembering things which didn't happen because his memory is clouded by time and by his position giving evidence and by the civil litigation process. It doesn't much matter. But the judge should not have accepted that evidence, and it was irrational for him to do so.
It doesn't much matter, except in this sense, that all the points you make about Mr. Mohammed having given untruthful evidence or acted dishonestly in other contexts don't help you in evaluating the likelihood of him misremembering.
Well, one starts with guessing. Assume that Mr. Mohammed is honest, a completely honest man coming to the court, doing his best to try to recall what happened. his memory, the court ought to have great caution about accepting evidence of that detail of a meeting 28 years ago, even if he's completely honest, because as Guessman
That's why I asked the submission whether you say the judge accepted the evidence uncritically, and if so, upon what you found at that submission, because the central message of Guessman is not to be uncritical of oral evidence. It is to say that oral evidence is likely to be unreliable, and therefore you have to be critical about it. But the submission against you is that the judge did examine the evidence critically, and he considered that, in part, it was reliable.
Well, I think Guessman goes further than that. If you go to paragraph 22, and I accept Guessman is not, no case is legislation, but the Justice Leggett says, in the light of these considered the best approach for a judge to adopt and trial of a commercial case, and whether this is a commercial case or family matters not, is to place little, if any, reliance at all on witnesses' recollections of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary
But as this court has observed in a number of subsequent cases, you can't do that when there are no documents.
Well, there are documents.
Well, there's no minutes of the November meeting.
No, but there are documents contemporaneous to the receipts which we say give the lie to what is said. That's our case.
But the issue is what was said at the meeting. There's no dispute the meeting took place.
A meeting took place, yes.
So the question is what was said, and there's no documentary record of what was said.
No.
So what is the judge supposed to do in your
Well,
submission?
the judge is supposed to look at the sea of evidence and say, right, well, Mr. Mohammed has given me an account of what he says we decided that we would have a new trust. That's what he said, and that I and C2 and D14 would be trustees of this new trust. Now, I have evidence from other people about a meeting or meetings, but no one gives that detail. But Mr. Mohammed is clear about that. Now, that's quite a level of detail to remember about a meeting that's undocumented 20 years ago. Can I rely upon that evidence? Is it accurate? Let us look and see whether it is corroborated by any contemporaneous documentary evidence. And we say it is not. In fact, it's quite the opposite. When he started to raise the money, he was handing out receipts which were clearly in the name of the Dewsbury Trust. And he knew that, as the judge finds, and entirely understandably. He's an accountant, he's not stupid. And he's handing out receipts clearly in the name of the Dewsbury Trust. He's opening a bank account in the name of the Dewsbury Trust. Why? Because he knows he probably wouldn't get an account in the name of a new trust.
I know that we're dealing with a much later period.
Yes, I'm sorry.
No. But that argument would apply equally to the receipts handed out in 2012 or something, when they can't have been meant to be for the Dewsbury Trust.
I accept that, but whatever happens, I mean, you have, it's very narrow. You're looking to see, it's the intention of the donors.
No, I follow that. But you say, well, Mr. Mohammed wasn't stupid. He'd have known what he was doing. Well, there you're focusing on the intention of the donee.
Yes, I am.
And in 2012, they do the same.
Yes.
And if the point were a good one, then Mr. Mohammed would think, well, obviously this money is being lent to Dewsbury, when he can't have done.
Well, one doesn't know what he thought in 2012, but if you're looking at the intention, the point is it's the intention of the donors.
Yes.
What were they objectively thinking? I accept you can say, well, hold on, if you're right as a 1996, 97, 98, then 2012, the same must apply. 2012 is a long time after that, after events. Remember, the schism doesn't really occur until the mid-2010s, I think it's 2015, 2016. And it may well be it didn't matter to Mr. Mohammed at that stage, because as he keeps saying in his own evidence, repeatedly, there's a joint venture, we were friendly, we were a joint venture may not matter.
Yeah.
But the judge found he was clearly, at 1994, 95, 96, he was clearly aware what the receipts said. And so I'm moving on, but I'm dealing with that point about the significant event. And I say, I make 2 points. One, we will still not remember important details of various significant events in our life. And secondly, it's all the more reason we would submit why the evidence needs to be tested in the guessing way. Can I go back to where my learned friend started? My learned friend gave you a very interesting account of the evidence about the movement and the hierarchy. And he said that he said I'd sort of island hopped that. I didn't. I seem to recall at the very outset of my submissions, I dealt with the judge's findings in relation to the nature of the movement, the other mosques, the ownership of the other mosques, and the accounts. And those are the paragraphs which led up to his finding in relation to the 1994 meeting. And I accepted that our case had been that there was a presumption, effectively, that properties would be owned by Dewsbury. And the judge rejected that. And my learned friend then eventually drew you to paragraph 71 of the judgment. Oh, sorry, 70 and 71. But I would put in context, I drew your attention to paragraph 77. And my submission would be that the judge's endpoint in relation to consideration of the various history of the movement, both in abroad and in England, and the ownership of various properties, he arrives at the conclusion in 77. It was entirely up to the donors with what intention they made their donation or loan. And I accept that. And the point is that the judge didn't find there was a presumption one way or the other.
Or except at the end of 76, he says properties tended to be locally owned. So he wasn't saying that that was determinative. That's the point he's making in 77. But nevertheless, there was a tendency.
Yes, that's right. I mean, my learned friend has pointed to the various properties, and I dealt with Blackburn and I think Leicester. I think my learned friend conceded that the Leicester property is actually in the name of whatever the accounts say is actually in the name of the Dewsbury Trust.
I don't think he did concede that. He said that the name on the transfer was that of the Dewsbury Trust. He didn't accept Dewsbury Trust was actually.
That's right. He says it's beneficial, but what? The premises are being placed in malfunction. And just reading what the point you've quoted to me, not follow the premises are being placed in malfunction. It does not follow the ownership. Well, they were being. It's clear there's evidence that other properties are, if they're not held as I think it's Leicester is technically in the name of the trust, they're held by other people who are trustees of Dewsbury. Now, where that gets one or not is may not assist one, but the point I'm making is that the judge arrives at paragraph 77 by saying effectively there's no presumption one way or the other. And so one has to consider the evidence in relation to this particular acquisition in that light. My learned friend again sought yesterday to distinguish between the London Trust and the Dewsbury Trust by saying there was a local element effectively. And he took you to, I think it's the core bundle, page 244. He directed you to the issue 1. It's the one I took you to, issue 1. And he said, well, look at what we say. And 244, the claimants in the 45th hold the land on the trust of the charity known as Andrew Islam Muslim of London, the charity contained in a declaration trust with the member, which was declared under the implied authority of the nation, so receiver claimants 14, the purpose and spirit of the gift, acquiring the land to fund the building. And I think he sought to draw your attention to the second part of that paragraph, which presumably he would say seeks to explain what the nature of the trust was. But with respect, he's not entitled to do that. His case is, and was, that it's held under the 96th Trust. And as my Lord Justice Henry has pointed out, there's no local element in the 96th Trust. And if one looks at what the judge actually held, paragraph 153 of his judgment, it's a page, it's core bundle divider 10, page 189. He says, accordingly, I conclude the land is held upon the trust of the 1996 Declaration Trust. That's what he's asked to find by the claimants, and that's what
Yes. Go back to 147, please. Just ask. 147, otherwise 152 is incomplete in isolation.
157.
147.
147.
Conclusion of issue 2. I can't read issue 5 without issue 2. You have to see what he concluded in issue 2. Just ask you to ask the court
Yes,
to read 147.
right. The court I to read 147. I just don't accept, and I invite the court not to accept, that there's any substantive difference between the terms of the 96 Trust and the terms of the 1975 Trust. It's held on the terms of the 96 Trust, that's what the judge has declared. You can read the 96 Trust and you can read the 1974 Trust. The relevant parts are the same. You were taken, I think, today, I'm moving on to today, to say, my learned friend said paragraph 70 and 71 are pivotal. I've dealt with that. One has to read paragraph 77 as well. He took you twice, I think, to the affidavit of Mr. HHJ, who of course wasn't cross-examined, but he took you to a piece of cross-examination which is at supplemental bundle 4, divider 169. Page 951.
I wasn't keeping up, so supplemental 4 tab.
So it's internal. Sorry, it's supplemental 4.
Yep.
Divider 169.
Yep.
Page 951.
Thanks.
Internal page 628 and 629. And my learned friend took you to, this is in the cross-examination of Daji about Mr. HHJ's evidence. And he took you to, he started I think at 627. And then he took Mr. Daji to paragraphs 11 and 12 of Mr. HHJ's affidavit. Is he right about that? And at line 15, right about that there. Answer, yes. Question, the Dewsbury trustees were concerned about a large new marquess in London. Answer, yes. Question, because in 1996 Dewsbury was at the top of the hierarchy. Answer, Question, Dewsbury is a very small town, West Yorkshire. Answer, yes. Question, and London is the capital. Answer, yes. If there was a big new Tablighi mosque in London, answer, yes. That might end up becoming more important than the Dewsbury marquess. Answer, no. Question, what was the concern you had? That was the concern you had, was it not? Answer, no, because it would be a branch of the Anjuman al-Islam al-Muslimin under Dewsbury, always. This is not the aim and object of the project. This is how the Tablighi Jamaat works. So, in order to put Mr. Daji's acceptance of what Mr. HHJ said in context, you have to read on and see what his answer was in that part of the cross-examination. He wasn't accepting that London, the new London Mosque, was going to be separate to the Dewsbury Trust. you've been taken to the facts. My learned friend discussed this morning the transfer of the land into C1, C2 and D14. You've been taken to the facts of the 2nd of November 96 from Dewsbury. It's clear at that stage, just before the transfer, that Dewsbury thought the property should have been transferred into the names of the Dewsbury Trust. And my learned friend mentioned Mr. Okai, who were taken to the Forsyth's letter. Whether or not Mr. Okai is a real individual, Merrymead, the company of which he was said, is a creature of C1, and you'll see that if you go to Supplemental Bundle 1, Divider 30. Page 274. And this is the letter, of course, Mr. Mohammed accepted that it was him that signed it as Abu Umar, and that Abu Umar was a false name that he adopted.
I absolutely follow that. Just to understand, the directors are given as these three individuals.
Yeah.
Is it that Abu Umar didn't exist at all, even though he's in company's houses here? Or?
I don't know. I haven't gone with it, but it was a false name, as I understand it. It was he signs as Abu Umar and Abu. All right. I'm reminded by Mr. Loveday that Abu Umar means father of Umar, and Umar was Mr. Mohammed's son. A minor point, just might disturb.
But it's a bit odd, isn't it? Because on any view, he's not trying to disassociate himself from this company when he holds himself out as being a director of it.
No, I mean, well, I'm dealing with Mr. Okai, who turns up, mentioned in one of the letters from Forsyth, on the earlier list of both sides. Yes, it's odd. I can't explain it, but the fact is, he accepted in cross-examination that Abu Umar didn't exist and was in fact him, and that letter was signed by him. And I think the cross-examination is he didn't really accept that there was nothing wrong with that. My learned friend then showed you the two draft contract. I think he showed you one draft contract at supplemental 2. It's 56 and 57. He showed you 57, and my Lord Justice Newey reminded him that there was a previous document dated 56. Those are the draft contracts, and there. He took you to supplemental 2. Divider 57, page 320 and following. And his point, I think, was that that draft contract, which is dated 7th of August 1996, had the name of the London Trust on it, and it was pointed out to him that back over the page there is another draft on exactly the same date with a different purchaser, and indeed the correction are not to add London in that, but to the spelling of Muslim. My only point is that both of those are 7th of August 1996, so they're considerably further on in the process, and they're just before, or some months before the date of the transfer.
And in particular, you say it's apparent that even as late as August 1996, a document was being prepared without London in the name.
Yes, yes.
And then London does get into the name.
Sorry?
And then London does get into the name.
Yes, oh yes, it does. It clearly was transferred in November into the we see the transfer. I made the point when my learned friend said that the dispute arose because the Dewsbury trustees wanted to sell the land at some time in the later 90s. That is true. The point I wanted to make simply was that it wasn't, there was a coherent reason for that. It was because the site turned out was polluted and was going to be very difficult to redevelop. That's the evidence. And can I then deal with my learned friend, briefly with my learned friend's points on receipts? He started by making a distinction between a donation and a receipt. It's the donation that counts and not the receipt.
I'm not sure he did say that. As I understood the point he was making, what he was saying was that the point of the receipt was to acknowledge the debt.
I thought before that he distinguished. I'll answer that point.
His point was you get the receipt after you formed your intention to donate and not before.
Yes.
Which I assume you would accept.
I would, or to lend, I would. But the court has to ascertain what the objective intention was. And as I said, if I form an objective intention to give to the RNLI, say nothing about it, donate it and get a receipt from the Guide Dogs for the Blind, an objective view is that I've given to the Guide Dogs for the Blind.
As it happens, when I came through Charing Cross this morning, there were people dressed in yellow collecting for the RNLI.
Did you get a receipt, my lord?
I didn't test what receipt they might have given.
But no, one gets a receipt for, I would submit, for three reasons. One, and this is receipts for loans. The judge's finding was that most of the money, over £1 million, he says, it's paragraph 87 of his judgment, over £1 million of the money came in loans, goodly loans. So most of those who handed over money received a receipt because got a loan. You receive a receipt for three reasons. One, to acknowledge that you've handed over money. Two, to acknowledge how much money you've handed over. And three, to acknowledge to whom you've handed money over. And I accept you can say, well, there's a conceptual difference between a decision to donate, which comes first, and the receiving of a receipt, which technically comes after that. But even if there is some sort of gap in time between one and the other, as I said, the point is, well, what is the objectively ascertained intention of the donor? How does one ascertain that? If the donor says, here's the money for the London Marquess, and gets a receipt which says from Dewsbury for the London Marquess, an objective view is inevitably and ineluctably that the money was given to Dewsbury for the London Marquess. It's simple as that. Now, I say there's a conceptual difference, but it's conceptual rather than real, and it departs from reality in most practical circumstances, I would submit. And to attempt to discount the evidential value of the receipts by reliance upon such conceptual points, as I say, it departs from reality and is not one that either the judge should have or this court should countenance. And the same goes for Mr. Raman. My little friend took you to paragraph 9 of Mr. Raman's statement. I've previously taken you to that. And his point was that he thought that he was giving to the London Trust. But there's no evidence he ever, when he received the receipt, he ever said, queried that. Or did anything other than subjectively think that he was giving to London, despite what the receipt said. And I made my points on that, even if there was evidence to justify that some people thought they were giving to London when they got are dues early receipt, unless they said something about it at the time or there was some objectively ascertainable evidence that they were giving to London as opposed to Dewsbury. The fact that they said nothing and received a receipt is irrelevant in my submission. And remember, even on C1's case, there's only 60 people at this meeting, I think he says, in November 94. So there are hundreds, if not thousands, of donors. So not all of them, by any means, a tiny fraction of them will have been at the November meeting. And how do you say the evidence of these hundreds of thousands of donors, hundreds or thousands of donors, is to be ascertained? You look at the receipts they got. Forgive me, I'm just checking through my notes. My lords, that's all.
And I don't take any more questions, so thank you very much, Mr. Holland. And as you'd anticipate, we will not be giving judgment here and now. In advance of the hand down, which of course, in accordance with what is now the practice, will be remote rather than in a courtroom, you will of course be provided with a draft, and we'd be grateful if at that stage you would seek to point out our typing and similar mistakes. It isn't, of course, an occasion to re-argue the case. You've helpfully provided details of those to whom the draft can go. Should there be anybody else who you think needs to see the draft, please come back to us. You'll remember how much importance is attached to the confidentiality obligation. In advance, again, of the hand down, we'd be grateful if you would seek to agree an order dealing with consequential matters. If there are any points on which you disagree, then could we please have brief written submissions, and we would expect to deal with the points in the order that we make. But it remains to say thank you both very much for your very helpful submissions.
Just a reminder to the